Brings us to item B, second reading on CUP 14-04. Mr. Thompson.
Yes, ma'am. What you have in front of you is a conditional use permit to operate a church/house of worship in the Fountain Square Shopping Center at 2148 Fountain Square, Snellville, Georgia. The present zoning is BG. In order to operate a house of worship in a BG zoning district, you have to request a conditional use permit. This is a typical use that's been found in this shopping center. I believe there are 2 or 3 currently there. They've met the conditions of the conditional use permit. We recommend approval with the recommended conditions as stated in the staff report.
Questions for Mr. Thompson? Thank you, Mr. Thompson. Is the applicant or a representative of the applicant present? Would you like to say anything, sir? If you would, please state your name and address for the record.
My name is Senior Apostle Conley John for Cherubim and Seraphim Church, Snellville.
Gonna have to spell that for our city clerk. If you could meet with her after, when we take a break or after the meeting, that would be great.
I can spell it right now.
Okay. If you want to write it on the form there, the sign-in form, that would be fine too.
Okay. Thank you, Mayor and the council members. We do appreciate for giving us the opportunity to come today for this hearing. We're going to be operating according to God's and Jesus Christ's belief, and without any problem, and we hope everything will be okay.
Thank you, sir. Does anyone have any questions for the applicant? Thank you, sir. Would anyone like to speak for or against this application? If so, please come forward. Okay. I will close the public comment section of this meeting and ask for a vote of council.
Mayor, I'd like to make the motion. Make a motion that we approve CUP 14-04 with the conditions stated by the Planning and Development.
There is a motion by Councilman Kraus. Is there a second?
Second.
Second by Councilman Emanuel. Any further discussion by council? Seeing none, I'll call the question. All those in favor of approval of CUP 14-04 with the recommendations of the Planning Department signify by raising your right hand. That's 6 in favor. All those opposed, 0 opposed. The motion stands approved. That now brings us to our new business, a report by the city attorney on the Couch litigation. Mr. Powell.
Mayor and council, it is unusual that we give a report on litigation matters, but it's been unusual from the very beginning in this case because it's between the mayor and council members, in which situation we've not been allowed to have executive sessions for that discussion. So this process has been very public and very open, and so for that reason we give a very public and very open report tonight on the outcome of the case. The first thing I'd like to report to the citizens of Snellville is the exemplary courage on behalf of my clients, the council of the city of Snellville, and the employees.
Mr. Powell, before you go any further, I want to clarify a few things since you just brought it up. Who are you here tonight giving a report on behalf of, and who are your clients? Since you just said it was the city council and city employees, let's make that clear.
I am really proud to report to you that I am the city attorney of the city of Snellville, and I'm here to give a report as your city attorney.
And you also represented the defendants in the case you are reporting on.
Which really is the city of Snellville. The defendants in this case are the elected governing authority, And the debate that we're having right now, the mayor and I often do legal discussions, and this legal discussion has been one of those that's been ongoing, and it's roles of ethics. This is an unusual case in that I spent 2 hours on the stand first, and so that role in the judge making a determination as to the proper ethical considerations involved in the case for me was resolved early on. And as a result of that, we resolved the issue of who I represented, which was the city of Snellville. And I'm here to report on that, simply to give my, as city attorney, a report on the procedural status of the case, where we stand, what was resolved in this litigation.
And Mr. Powell, before you go further, you alluded to the fact that it is unusual for you to give a report on an actual agenda. Usually we handle this in exec session or in the work session. So any privilege, any confidentiality issues your clients are waiving by you giving this report tonight?
I'm not giving any confidential communication. These are all public record issues. They're the resolution of the settlement agreement, the pleadings in the case, all of which are public record, the actual transcript of the case. I don't want to vary into what I would consider to be confidential communications, but this case has been tried, and it is concluded in as far as the issues that were before this court, before the court in resolution of this case. So these are not confidential communications, and I am not waiving any attorney-client privilege by giving this report. It was an exceptional degree of courage. Anytime you're in a lawsuit when you're battling for 2 weeks, which is what this was, a 2-week period of time, it took people who I think are making about $300 a month out of their normal professions and away from their regular work schedule and put them into what is a pressure cooker environment of where they were both facing the difficulty of making decisions on behalf of their city that were long-lasting concerning whether it would be governed as a democracy or not. And they were battling over those issues while at the same time having to deal with the pressure cooker that their administrative staff had been put through. As a result of a trial tactic that was used, there was a division created in the process between the administrative staff and their employment and the city council and its resolve to defend the best interests of the city. And that results in both pressure and tears. And this council was up to the job and answered the call. And you can't report this case to the citizens of Snellville without making sure everybody understood that. Likewise, Ms. Arnold deserves credit for her strength. She has a heart that is just magnificent. And she did not make it all the way through the process. But the reason she is not city clerk today, I believe, is because she chose, because she couldn't withstand the pressure of the events of this case. And that gives you an idea of the difficulty of it. In the division of accusations, there was a much displayed threat of what was contempt and imprisonment for your city manager on the basis of a deposition that was done the day before the trial. And his answers and responses to that, I'm happy to report he sent to me. A clear indication that the University of Georgia is recognizing him for his degree. And I give Butch an opportunity to report on that aspect of this case.
I appreciate that, Mr. Powell. I certainly didn't ask for this item to be put on the agenda, but when I saw litigation, there was one loose end that I said during the trial that I would clear up one way or the other. And I'd like the opportunity to do that. And that does concern my educational attainment. It was called into question, and I voluntarily produced a transcript which clearly showed that I had met every requirement for the Master of Public Administration degree. I felt then, and I felt for 25 years that I felt like I had earned the degree and had the degree. One thing that was not on that transcript was a notation that the degree had been awarded. It was not on there. And I asked for some time to clear that up. I said I would go to UGA and I would bring a report back. I'd like to bring that report back tonight. Very clearly, got a note received a couple weeks ago from the Director of Graduate Student Services, Sherry Bliss. Says, in response to your phone call and emails from last month, your file has been reviewed by both the graduate school and faculty in the Public Administration Department. Had a chance to talk to my old department director. All paperwork on file indicates you did complete requirements for the MPA degree. I apologize for this error and that it was not addressed sooner. Please let me know if you have any questions. And lo and behold, they've even sent me another piece of paper. It's not something that I have ever put on a wall. When I left the University of Georgia after completing my degree requirements, I had to go to the city. I had to go to Atlanta to pay bills. I worked my way through college, but I'm proud to show the diploma which I earned 20 some odd years ago. So, I would just ask that, that this issue finally be put to bed. Thank you.
Procedural status of the case is that it only went through the presentation of the plaintiff's case. And that means that this case was resolved at the conclusion of the presentation of the plaintiff's case, where we had just made a motion for what is the equivalent of a directed verdict as a motion to dismiss. I think from my client's perspective, the good news about that is they didn't waste one dime of this city's money putting up a defense in this case, other than the cross-examination of what the plaintiff put up. And it did not require to go beyond that. 2 weeks of trial, broken up by intervening days, is a very expensive way to try a case. Division, where you have conflicts of interest alleged between administrative staff, not just alleged, but created by the settlement negotiations in the case, also created a necessity that this case be tried by two firms representing the interest of both, representing the interest of those parties, both our firm and the Kevin Tallent's firm. I can't go beyond that point without saying what an excellent job Mr. Tallent's firm did on behalf of those administrative staff members. Those divisions, though, also create an expensive way to try a case. It was tactical on the plaintiff's part and something that just had to be met defensively. The judge, in discussing the directed verdict motion, did not rule on the directed verdict, but he did make clear how he was interpreting the evidence at the time. And when Ms. Miller, once we made the motion for directed verdict, Ms. Miller made an argument otherwise. Ms. Miller's argument ends and the court responds this way: the city clerk is problematic. I'm going to step off the bench on that one. I've got an idea. I actually think the 2010 amendment resolves it. Now, what the judge was referring to in the 2010 amendment was the key issue with regard to the clerk. And that is, if we could have this overhead. That is this home rule amendment. And the issue pertained to whether or not the mayor and council had changed the issue of an annual appointment. And you can see in the notice provision, which your code requires to be a specific complete statement of the essence of the resolution, it said that in 2010 this council intended to delete the requirement for annual appointment of the city clerk by the mayor and council to serve at the pleasure of the mayor and council. That's where the mayor got the sole authority to make the appointment. It also came in a clear resolution in which it was stated that there would be no more annual appointments. And this body acted on that from the date of this amendment until the date of this year, when the issue arose in 2014. There were no annual appointments, and the court had that evidence before them. What was most compelling was that Council Member Kelly Kautz, the plaintiff in the case, signed that amendment. And when the court referred to that in saying this is problematic, it was problematic to the plaintiff. The court went on to state these things. My gut feeling on clerk is a little bit different, but anyway, I'm going to just take 10 minutes. We'll be back at 3:10. The court stated the open meetings, that's actually somewhat tied into the clerk in a way because it was that event there, the appointment day. I'm going to get a cup of coffee. That is what it really amounts to, but I'll rule on that one as well. Now, when you're ruling on it at that stage, it's a good thing for the defense of the case. And the court concluded very clearly on page 108 of the transcript, line 22, I have 3 counts that are going to be gone. So it was clearly announced by the court that there were 3 counts that were going to be gone, and the resolution of that puts us in these positions. First of all, there was nothing at that point that could be done for Ms. Arnold. The clerk's position was open. That was not a matter of litigation. This provision says that the mayor gets the sole appointment power. She exercised that in this case, and we have Ms. Richardson's appointment. But there was nothing for the court to do as far as that office position. This council did not compromise Ms. Arnold's position. Ms. Arnold resigned that position under the stress of the litigation. She was not a part of a ruling at that point. The judge announced very clearly in page 94 through 102 of the transcript that he was ruling in the council's favor on the mayor's veto power to sign all checks. He did not see that as a matter of right to the position of mayor. It was clearly a legal remedy if she thought an expenditure was improper, and that was clearly stated by the court. Whether or not the plaintiff has executive powers beyond those specifically listed in the charter and approved by the council has been resolved by the doctrine of res judicata. Those were clearly pled within the complaint. They have been dismissed with prejudice by the plaintiff in this case. They are bound by that. That dismissal with prejudice resolves that issue of executive authority beyond that of the stated charter. Whether or not a group of defendants violated the Open Meetings Act on 5:30 p.m. on January the 10th, 2014 was resolved by consent and by a statement of the plaintiff that no such violation occurred in the body of the settlement agreement. For this group, testimony was pretty clear that this group gathered in order to lend support to Melissa Arnold very kindly. That's where this accusation arose, and to clearly be accused of a criminal conduct in that setting created much of the pressure of the trial of the case also. It was done in compassion for a person, and to have that used was also very stressful. But to clearly resolve it was a real victory of the settlement agreement, and it's clearly stated within the terms of the agreement that the plaintiff recognized that to never have occurred. The remaining issue is whether Butch Sanders would remain as the city manager, and that became the crux of settlement negotiations and the leverage of this council's decision to make a compromise in this case. And the compromise that was made was he would stay until at least December 31st, 2015. And he has an obligation under the settlement agreement to resign at that point, but he is not barred from being reappointed to that position if the council so chooses. The value of that to the stability of the city was significant, and it represents, under the setting, a real compliment to the city manager as to his value to this city. There was confusion by the judge on that subject matter. As your attorney, I had no doubt that ultimately we would win that issue, but there was some question in the court's mind, and a lack of leadership in the city for a period of time of appeal was something that this council felt like was critical, and for that reason the settlement was entered into. The issues that have been carved out are those that are pending before Judge Hamel. And these issues are issues that have not been resolved. Whether or not the mayor pro tem is appointed by the mayor solely, whether or not the plaintiff has the right to terminate the city solicitor, Jennifer White, whether or not the court should issue a writ of mandamus or injunctive relief to stop the mayor from disrupting meetings of the city council by breaking the procedural rules and Robert's Rules of Order, whether or not the plaintiff has the right to appoint boards and authorities of the city without council confirmation, whether or not the plaintiff has the right to unilaterally appoint board members to the Snellville Tourism and Trade, whether or not the home rule amendments, which include those from 2010 and 13, are in fact valid, whether or not the plaintiff has the right to terminate the city's municipal court judge, whether or not the court should issue a writ of mandamus or injunctive relief to compel the plaintiff to perform the duties of her office without interfering with operation of city government, whether or not the plaintiff has the power to terminate the clerk, whether or not the plaintiff has the power to terminate the city manager, whether or not the plaintiff has the power to terminate the city attorney, and whether or not the term of Butch Sanders is at the pleasure of the mayor and council, whether or not the city manager form of government approved by the General Assembly for the city of Snellville creates a professional city manager for the administrative operations of the city, leaving the mayor with the limited role of chairing the city council and performing functions specifically listed in the charter. Now, those are issues which are, by ruling of the court, still pending before Judge Hamel. They are pending on appeal. That issue currently resides in a petition for cert. Y'all have seen the ruling of the Court of Appeals in favor only on the limited issue of the city attorney, where they said the mayor did not have the authority for termination. And so it's a ruling that's been before them for several months now. They are on, I think, recess at this point. They should have already voted one time with regard to that petition for cert, but we should hear something within the next 30 to 45 days. Those are issues, obviously, that were peeled off in the original motions at the beginning of the trial of the case, and which are still pending before Judge Hamel. In the beginning of this action, I estimated that the cost of this suit filed by the plaintiff would be in the range of $100,000. I've missed my mark slightly. The charge that we've billed the city for this effort, which was significant in terms of its attention, was $80,233. The additional charges of $35,412.29 were charged by the talent. My estimate was $100,000. It's $15,000 over, and I believe those are caused by the ethical challenges and the tactics with regard to the division of the interest of the administrative staff from the council, and the necessity to have additional counsel within the trial of the case. The cost is significant from a lawyer's standpoint. There are valuable rulings that have taken place within this that support democratic government within the city. The only issue remaining, both parties have clearly dismissed with prejudice on the mayor's part with regard to the claims. The mayor has requested and severed by the settlement agreement a claim for the citizens of Snellville to pay legal fees. She was represented by former Superior Court Judge Mike Clark in his first case back before that jurisdiction, as far as I know, and former juvenile court Judge Phyllis Miller, along with an Atlanta attorney, 3 council members. Estimated during the settlement negotiations at somewhere in the $250,000 range. There was a settlement offer to accept a match of our fee structure, which I think they'll be surprised at, the amount of it. The hearing is set for August the 19th at 1:30 before Judge Davis in courtroom 3E. Again, the balance of these issues that have been reserved are before Judge Hamel. Once that appeal is resolved, I would expect the case to be remanded, and the remaining issues which are important to this council's continued operation to be brought before Judge Hamel at a cost that would be significantly less. These are really legal issues. They are not emotional issues about Mr. Sanders' history, which turned out to be obviously a wonderful opportunity for him to get a diploma. But this case is about how Snellville operates, and so these issues are legal issues that should be resolved by a court without a great deal of emotion or testimony with regard to those types of issues, or pressure in terms of these are really issues that are municipal, legal, simple, and should be handled and adjudicated that way to the best interest of the citizens of Snellville. So that's my full report. If there are any issues that you have that you would like answered, I'll be glad to do that.
Questions for Mr. Powell? Thank you, Mr. Powell. I have a couple of things. You know, I don't want to keep doing this dance. I'm pregnant. I'm tired. I agreed to settle this case because I didn't want the stress of it when I was going through my first pregnancy. But since we settled, it's been even more intense than it was in the courtroom. Yourself and this council have continued this case going for no reason other than a power struggle. And you're right, you are the city attorney. And as city attorney, you have a duty to represent all of us up here. You just did a good job presenting your client, and you referred to him as my clients several times in your presentation. And you referred to the council members. You doing this report tonight were to do it as city attorney, not the defense attorney. You have an ethical obligation to represent the interests of the city, and that includes the mayor's office, and you have not done that tonight, sir. You've done an excellent, let me finish, sir. Actually, you can sit down because this is a statement, not any questions for you. So if you could sit down while I address my statement, I would appreciate it.
I would like that.
If you would sit down while I give my comments, I would appreciate it. You did an excellent job of presenting your side of the case, just like you did in court, of how the defendants felt that everything was presented. But we all know that this was a settlement agreement that was agreed to by both sides. And neither side would have entered into the settlement agreement if winning at trial was 100%. Nothing was a slam dunk for either side. Nothing was ruled on by the judge for either side. You mischaracterized several things today that were not actually ruled on by the judge. He did say that he was not going to. I filed for what's called a temporary injunction or temporary restraining order on the issue of checks, and checks being issued in the city of Snellville without my signature. What the judge ruled on was not whether or not that fiduciary duty belonged to the city manager. What he said was, for temporary injunction, you have to first exhaust all other remedies. And I had a remedy by going to the bank and reporting that the checks were not valid, that I hadn't exhausted. So he was not going to rule on that because I hadn't exhausted all other remedies. It's what we call in legal terms an equitable remedy, and we have to exhaust everything else first. You said that res judicata bars the executive powers claim. Nowhere in my case did I ever argue about who is CEO of the city. That was actually a defense that was raised by members of the city council. We actually had members of the General Assembly who said yes, the mayor was the CEO of the city. We had Mayor Oberholzer and Mayor Harrell who said yes, the mayor is the CEO of the city. Every member of this council took the witness stand, and when they were asked who the CEO of the city was, and Mr. Sanders, they all said we don't have one, that we operate unlike any other government in the United States, and we don't have 3 branches of government. We don't have an executive branch. We operate with only a legislative branch. So the issue of CEO was never decided by the court, and it is quite clear in the city charter that the mayor is CEO. In fact, I believe that Councilman Emanuel was asked the question who the legislative branch is, and I think his response was the city council. And the question was, who says that? And it was the city charter, and it was the title of the city charter. And then he was asked, what does the title by mayor say? And he said, Chief Executive Officer. But the response was, his reasoning was the title doesn't apply to the mayor, it only applies to the council. When you're referring to the council, titles count, but when you're referring to the mayor, titles don't count. That's just not right, and that's not accurate. But regardless, the issue of CEO was never decided by the judge. The judge did say it would be difficult to decide the issue of open meetings, and I did agree as part of the settlement to drop any claim I had as far as open meeting violations. The judge did say, as he was considering the directed verdict, that he believed because council ratified a contract with the city manager, and that contract had a specific term that expired on December 31st, he believed that was going to be problematic for the council and that he was going to deny that directed verdict. He did say that the city clerk position was a little bit more problematic and he was going to step off the bench and have a coffee break. But Mr. Powell left out of his comments was when the judge got back on the bench, when he took that coffee break, is when we, as the two parties, reached a settlement agreement. The judge came back on the bench and said that he had made up his mind and did we want him to announce it on the record. He had decided to deny the directed verdict and to allow testimony and decide the city clerk issue after hearing all the testimony. But it was actually Mr. Powell who insisted he not read that on the record because we had reached a settlement agreement and he did not want that announcement to affect the settlement agreement or the terms of the settlement agreement. The judge said that yes, he had 3 issues or 4 issues he could rule on right then and there, one being the open meetings, one being the fact that the mayor's signature had been used, a stamp of my signature was being used without my permission, and that to him was a no-brainer that you can't use my signature without permission. One being the fact of the checks and that I hadn't exhausted the remedies, and one being the fact that I was kept out of certain areas of City Hall, and that he had made his opinion clear on that he thought that was not a wise decision by staff and whoever had made that decision. Mr. Powell put up here the signature he left up here for us to look at of the Home Rule Ordinance 2010-04. This was a long and complicated argument as to whether the annual appointment of the city clerk was repealed in 2010 or not, because we had a charter provision and we had an ordinance provision, and both sides went back and forth, and this is really what the judge needed to consider. It's irrelevant now because the last council meeting has revoked this ordinance, and so the annual appointment doesn't exist one way or the other. But this was the crucial issue that was going to be decided by the judge, and this is probably what drove the settlement, is because it could have gone either way. But the bottom line is that the whole reason we settled this case, and if you read and I don't have a copy of the settlement agreement with me tonight, but if you read the very first paragraph of the settlement agreement, it said it was a compromise reached by all the parties because we wanted to move forward, we wanted to stop the bickering, and we wanted to do what's best for the city. But ever since then, this council has put things on our agenda that just bring it all back up. It's politicking and it's not healthy, and it's time for us to move on. Mr. Powell, I appreciate that you're doing your job for your clients, as you referred to them, but you're not doing your job for the city. So I ask you to please move on from this because it is not helping anyone.
The CEO issue is spread throughout the pleadings of the case and was argued both in pretrial motions and during the trial. Witnesses were put up for that purpose. I agree with the mayor in terms of moving on. That's a good idea. The amount of resources of this city that are going to this effort is unnecessary. The people filing these cases need to stop. That's in the best interest of the city. The issues can be resolved simply and without pressure. You don't have to put the administrative staff in the ringer with depositions and notices and subpoenas in order to figure out who gets to appoint the clerk. Those things have been communicated clearly over the past about how it could be done easily and without confrontation, so that everybody could get together and disagree in a very pleasant way in front of a judge and get it resolved. I highly recommend that be the method of resolution of these issues in the future. It has never been my wish to report to this council on this case, to try this case, to charge for this case, to defend those issues was never my idea. But for good people to be put in that place of having to defend themselves. I think they are up to that task, and the city's interest in this will be defended. And it was important, I think, because of the nature of communications these days, and social media are rampant with half-truths, and this is the truth. The judge did not, the mayor is right, the judge did not rule. He said exactly what I read to you tonight. And that resulted in the collapse of this case at the end of the plaintiff's case, and it was resolved. We are pleased with that settlement because we protected our city manager. We are proud of him and proud of his work. We appreciate that settlement. We are good to move forward, and we did at the earliest possible opportunity. And to continue to do that, I think is my wish. I join the mayor in the wish that we stop doing it this way, that we get back to the peaceful business of building sidewalks and town centers and good things for the citizens of Snellville, and quit wasting their money on legal fees.
Does that mean you're going to advise your clients to withdraw their counterclaim?
You know, that case too is one that has a plaintiff, Mayor. And as long as the plaintiff is pursuing.
My case is
then
over. The only counterclaim is still pending, Mr. Powell, so don't put it on me.
This case right now, jurisdictionally, Mayor, is in the Supreme Court at your request. I'm sure if you dismiss that,
The
and let the ruling
counterclaim,
stand,
the
I'm
counterclaim
sure
is,
the council will consider that.
the counterclaim is not in the Supreme Court, and I believe yourself have argued that the counterclaim is not abated, or excuse me, is not superseded by the Supreme Court case.
So that we're clear, Mayor, there is one plaintiff in that case, it's you. You are pursuing your claim against the council and the citizens of Snellville. You are currently pursuing that in the Supreme Court at your request, not ours. And you dismiss that, and I think that'll go a long way towards this council settling.
Mr. Powell, to clarify, I do not have a case against the citizens of Snellville or the city of Snellville. The case, just so the public is clear, the case that's pending in the Supreme Court is whether or not the mayor who appoints the city attorney also has the authority to terminate the city attorney. The counterclaim that is pending are the several things that you read into the record previously that had to do with the city judge and the mayor pro tem and things of that nature. Is that fair?
Those are important things. Those are really important things for resolution, Mayor. I mean, if we're going to fight over those things and want to fire all the appointed officials, then those are things that have to be defended because those positions are important. It's the full council's right to participate in that process. The charter has been clear that they serve at the pleasure not of one person, but of the group. It is a democracy in Snellville.
Okay, I'll take that as a no. Thank you, Mr. Powell. Our next item agenda is consideration action on resolution on oath of office and work schedule for the city clerk.